At this point, I would like to call the meeting to order. Today is Thursday, February 27th, 2025, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. I would like to ask Commissioner Paris to make the land acknowledgement.
The West Hollywood Rent Stabilization Commission acknowledges that the land upon which we gather, that is currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Kizh peoples.
Thank you very much. And I'd like to ask Commissioner Topchin to lead us in the Pledge of Allegiance.
Thank you, Chair. Please rise and join me in the pledge.
I pledge allegiance to the flag of the United States of America and the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Ms. Secretary, may we have a roll call, please?
Commissioner Goldman?
Here.
Commissioner Kerpes?
Here.
Commissioner McCafferty?
Here.
Commissioner Paris?
Here.
Commissioner Topchin?
Here.
Vice Chair Rory?
Here.
Chair Bass?
Here. We have a full house, a quorum. Has everyone had the chance to review tonight's agenda?
Motion to approve?
There's a motion to approve.
Second.
May we please have a roll call?
Commissioner Goldman?
Aye.
Commissioner Kerpes?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Paris?
Aye.
Commissioner Topchin?
Aye.
Vice Chair Rory?
Aye.
Chair Bass?
Aye. The motion carries. Now we'll move to the minutes from our meeting of February 13th, 2025. Has everyone had a chance to review them? I have one change. On page 5 of our packets, I don't know what page of the minutes it is, but item 9, number new business. The motion I originally made there was for a work session, but I believe through our conversation it changed to a date uncertain. So I'd like to change the motion to bring back to a date uncertain. It leaves it more open. And I believe that's what the actual final motion was. Unless there's objections from my colleagues.
Move as amended.
Second?
May we please have a roll call?
Commissioner Goldman?
Aye.
Commissioner Kerpes?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Paris?
Aye.
Commissioner Topchin?
Aye.
Vice Chair Rory?
Aye.
Chair Bass?
Aye. The motion passes. We now move to item number 6 on our agenda, which is an opportunity for the public to address the commission on any items that are within our purview. Madam Secretary, do we have any comments from the public?
There are no public comments.
Thank you very much. So we'll move on to item number 7, which is the manager's report. Mr. Kessinger, may you please have a report?
Yes, thank you. Good evening, commissioners. It's nice to see you. Before I begin with the look-ahead calendar, I just wanted to follow up on 2 requests brought forward by commissioners at the last meeting. The first was for an update on seismic retrofit from Commissioner Kerpes. I did follow up with building and safety staff. They informed me that they will actually be presenting an update in April to the council and advised that they would be available for updates for commissions afterwards. So definitely stay tuned for that update in April for the council, and I'll follow up as requested by the commission following that update. Commissioner Topchin requested an update on when our government affairs liaison, Hernan Molina, would be available to present the update to the commission. We have tentatively scheduled that for March 27th, so you should see that reflected on the look-ahead calendar for the following commission meeting. In terms of our look-ahead calendar, this evening we only have 1 appeal. Unfortunately, there were 2 withdrawals that happened at a later point, so that will be the only item for tonight. On March 13th, we have 3 appeals. In the current look-ahead calendar, we have 3 appeals scheduled for March 27th. However, as I mentioned, that will likely be the legislative affairs update, and I'm tentatively planning on also having the long-range planning team come back and bring that presentation back with a staff report. We're also working on an FAQ based on some of the questions that were brought up in the first conversation, so commissioners can have that as an attachment. I would invite commissioners to forward any questions to us so we can add that to the FAQ and proactively address them as possible in the staff report and FAQ for that conversation, ideally sometime before mid-March when those staff reports will be due. On April 10th, we'll have 3 appeals, April 24th, 3 appeals, and currently only 1 appeal scheduled for May 8th, but stay tuned as that may change. That concludes the look ahead calendar and manager report for this time, but I'm available for any questions you might have.
Thank you. Are there any questions for our manager? Commissioner Kirpies.
Yeah, I just had one. We used to receive, and I think it was before you actually started, but we used to receive on a monthly basis through our manager, but from the nonprofit that handles our legal affairs for evictions for that month. Is that possible to start that up again? Usually I think he just called over and asked what the number was at the end of each month or something.
Absolutely. So to clarify, it's the number of evictions or number of clients represented?
Preferably number of evictions, but I don't know what number they give.
Okay,
exactly.
Absolutely. I can look into that. I'll bring an update.
Thanks.
I'm curious, on April 10th, one of the appeals is listed as DIH. I'm just not familiar with that abbreviation.
That is a department-initiated hearing. So in that case, it was something that was not a common area issue, but was frequent occurrence. And so the department itself, or the division in this case, initiated a hearing instead of a tenant or a landlord.
Oh, thank you. I appreciate that. Any additional questions for our manager at this time? No. Thank you very much. We will now move to the appeals section of our agenda. We have one appeal before us this evening, that is D4949. And Madam Secretary, do we have a representative of both the tenant and the landlord?
Yes.
Thank you. So first, the appellant, in this case that would be the landlord, will speak. They will have 5 minutes to provide an oral argument. The landlord will have the option of dividing your 5 minutes into 2 segments. You may use part of your 5 minutes, you can use the whole thing, however you would like to do it, but you'll get a rebuttal at the end. So just tell us at the beginning of when you start speaking, how you would like to divide that time. The respondent does not have the option of dividing their time. They will be given one segment of 5 minutes, the tenant will be, and they will have to use all of that at that point in time, or as much of it as they choose to use. So when it's your time to speak, you'll come up, speak, or we'll call on you on Zoom. You will please state your name, your city of residence for the record, and again, the appellant will tell us how they want to divide their time and proceed with their comments. But before we start with the public comment, we will receive a staff report, so I'll turn to our legal counsel and ask for that at this time. Thank you.
Thank you. Good evening, Commissioners. My name is Kellen Martz. I'm the legal counsel to the Rent Stabilization Commission. Tonight we have D-4949, address 1128 North Larrabee Street, unit number 2. In this case, the tenants filed for a rent decrease for a reduction or discontinuance of multiple housing services. Specifically, those housing services were moving their parking from the outdoor to the indoor, their ability to request towing services for unauthorized vehicles on their own, elimination of the online rent payment system, and removal of email as a method of communication with management. Specifically, as to the moving of the parking indoors, they cited several reasons why that was an inferior service. The removal of the towing services was stated as especially needed because of the area of town that they live in and multiple people parking in those spaces that were unauthorized. They explained the inconveniences of not being able to use the online rent payments, as well as the inconveniences of not being able to use email to speak with the landlord. The landlord's response in the hearings were that the parking was not an inferior service having it indoors. The response to the vehicle towing issue was that that was not actually a service that was ever offered to them. And I'm just summarizing these responses, and that the online rent payment was not a reduction in services, it was just a change in management style, and that it didn't actually inconvenience the tenants. And the same response was for the communication for the email. After the hearing, the rents were reduced on those 4 issues. Several of them are common area items, and the parking is only as to the tenants in question. The landlord has filed the appeal in this matter, stating it's clearly an error. It is not supported by findings or evidence in the record, that the decision is an abuse of discretion by the hearing examiner, and that it is contrary to the RSO or state law. In the landlord's actual appeal, they make 3 separate arguments. First, that the decision should not apply to certain apartments because those people were not living there at the time the decision was made. The landlord also challenges the removal of the towing services, again asserting that the tenants did not have a right to tow those vehicles and that they didn't have any documentation that showed that they had that right. And then third, the landlord disputes the reduction of the parking services matter and saying again that it is not an inferior service. So in light of the appeal, the commission must determine if there's substantial evidence in the record supporting the 4 different rent reductions. Staff believes that the hearing examiner did not err and that there is substantial evidence in the record to support the hearing examiner's decision. As to the reassignment of the parking spaces, while for many it might be better to have an indoor parking, it's not the subjective opinion of the landlord, it's through the eyes of the tenant, and if they can come up with credible reasons why that is a housing service to have it in the exterior as opposed to the interior, that can qualify as a housing service. And again, with the vehicle towing, as we talked about, I believe in our last hearings, testimony itself can be the basis for a decision without anything else. So the landlord found, or excuse me, the hearing examiner found that their testimony was credible as to that issue and the need for it, and that it was a housing service. And staff concurs with that decision. And then as to the removal of the online rent payments and the communication by email, those are, as the hearing examiner said, pretty clearly housing services, and staff agrees with that decision. So our recommendation is that the commission affirms the hearing examiner's decision and adopts the resolution saying the same. And that concludes my report.
Thank you very much. Are there questions of staff at this time? Commissioner Topchin.
Good evening. Mr. Maher, just to clarify, my belief was that the car can be towed if the property owner, the landlord, or the manager calls, not the tenant. Is there any rule on that? Because as a tenant, I myself experienced an issue years and years ago. When I called the towing company, they specifically said that your manager or landlord has to call. The tenants cannot.
I don't believe there's a law in the city on that. Most places would not let their tenants do it because they don't want to have liability on those issues. But if it's become a service, and the tow company will come and tow when the tenants call, then I don't believe there's anything in our municipal code or state law that prevents that. And some landlords may see that the tenants are the agent of, or the arm of the landlord, because they've said, yes, you can do that in the past.
Okay. Thank you. If I may, another question. Under the RSO, the housing services, clearly the service can be anything and everything, right? But under the definition, what I'm reading is it has to be somewhere, somehow identified that's a service. Am I understanding it correctly? It's mentioning the re-registration form or anything, well, besides the rental agreement, what would be confirmation or establishment of a housing service, a landlord provide the housing service? Thank you.
Yeah, it doesn't need to, so in the definition, if the registration does, if it's not on the registration form, as long as they speak credibly to it, then it is accepted as a form of a housing service. So the preference is written, and that's generally where we go from. But in the hearing examiner case, they can accept oral testimony as to the hearing services. And if they do find, then it will stand.
Okay, thank you, sir. Thank you, Chair.
Any additional questions at this time? Then,
Just
please.
one quick one. In terms of the record, I just wanted to confirm, I didn't see any pictures submitted on the parking space. And did I miss anything? Was it just testimony at the hearing about the inconvenience of the indoor parking space? Were there pictures?
I think there is one photo of a Prius, pretty dark. It looks like on my file it's page 37. That's what was submitted to us. I don't know if that's what they are using that for, but there is a photo of an exterior parking space.
46 in the paper version.
48 on the PDF.
Right, and then for page 46, that's tied to the page 45 where it's a letter kind of citing an improperly parked car that then got towed, I think, right?
Yeah, that's the only item we have that shows photos. So I think if you want to ask the tenants, probably better than that. But I checked the records, and those are all the photos that we have in the file.
Commissioner McCafferty?
For the questions presented, and I know you've answered this in the past, so my apologies. Is this tied to, are these numbers for the amounts tied to an ordinance? that staff
The
is
reduction
coming-
amounts?
Yeah.
Those would come from our regulations.
Okay.
And so the regulations have a guide, 2 to 100, that I'm just making that up, but those are only recommendations, and the hearing examiner can go outside of those. But they
Okay.
are in our regulations, yeah.
All right. Thank you so much.
Any additional questions at this time? Seeing none, we are going to turn to the landlord at this point in time. Mr. Rosenkrantz, you appealed this, so you'll have the opportunity to divide your time. Please just introduce yourself by your name, city of residence, and how you'd like to divide your time, and our secretary will let you know when that initial period has expired.
Good evening, Commissioners. This is Adam Rosenkrantz for 1128 Larrabee LLC. I am a resident of the city of Los Angeles. I am safely parked. Sorry, I tried to get home, but I work in Malibu, and frankly, it took me well over 2 hours to get here because of some of the road closures. But I would like to take maybe a minute and a half for my opening and then leave the balance for rebuttal.
That sounds good. Please proceed.
Okay, I appreciate the time again. One of the issues regarding the parking space has since been restored to the outdoor area, so I'm hoping that's a moot issue. I would just like to note, I think it's commonly held that a indoor parking space is, substantially better than something outdoors. It offers better protection. It's covered, it protects you from rain. So I couldn't imagine any reason in which that would be deemed to be an inferior or a reduction of service. So that really didn't kind of comport with my understanding. Regarding the issue of online rental payments were never removed by the owner. When this property was acquired by 1128 Larrabee LLC, we didn't have a online payment system. So it wasn't as if, one existed and it was taken away. But for what's relevant is at this point, we do now offer an online payment system. So we're pleased to do that. Regarding the issue concerning the towing service, I've represented a variety of landlords for a number of years and I've never had a scenario like this come up. And I'm really kind of disturbed by it. Number one, nothing was ever submitted to the evidence in the record other than the tenant's testimony to state that towing capabilities were provided. I believe the tenant stated that the landlord allowed tenants to do so. That's hearsay, right? It's hearsay to state that a prior landlord allowed something to be done without having any evidence submitted into the record substantiating
Mr.
the fact that
Rosenkrantz,
the
that's your
landlord
time.
previously. Okay, well, can I continue on and I'll just save the rest for my rebuttal for whatever's left?
Yes, please proceed.
Okay, I'll be quick. It was never provided as a housing service. That was proven. It was all hearsay. Section 60020 says in part that no individual rent adjustment shall be supported solely based on hearsay evidence. That was entirely hearsay. Secondly, there's a contract with a towing company. Liability is assigned to the landlord if you tow somebody erroneously or unlawfully. So no landlord would ever give a tenant the right to tow a car when it could be held liable if that towing was done improperly. If there was a dispute amongst other tenants and somebody towed somebody or a guest of a tenant and it was not done appropriately or within the provisions of the contract, the landlord could be held liable for that. So that just doesn't seem legally equitable, nor does it seem equitable on the basis of anything that I could come to see. And then lastly, as it relates to the tenants that were assigned rent reductions that don't live there, the landlord does concede that it did not provide a rent roll to substantiate which tenants had moved in on what date. But I would consider that to be a trivial defect. I had appeared before the commission previously where a tenant had failed to post notice as a condition precedent to a rent application, being submitted. This commission allowed for that hearing to go on, even though the tenant violated the unambiguous provisions of the code. So I'm asking that this be deemed a trivial defect. The city has records of when tenants moved into the property that's equally available to the city. Rent registration certificates were done. So the city has a basis of evidence that I can draw upon. Thank you very much. I will save the rest for my rebuttal.
Thank you. Madam Secretary, how much time does he have left?
He's got about a minute and 40 seconds.
Great. A minute and 40 seconds reserved for rebuttal. We will now turn to the tenant. I believe we have J.J. Mays with us in the room. You'll have 5 minutes. Just introduce yourself by name, city of residence, and you may begin. You'll have all 5 minutes.
My name is J.J. Mays. I reside at 1128 Larrabee Street, West Hollywood, apartment number 2. Just to cover all 4 things briefly, yes, the parking spot has been restored to us, which is great. In question as to why it was better than...
I'm sorry for interrupting, but I can't hear.
Okay. You'll just have to speak a little bit closer to it. Our tech folks are coming. One moment. Thank you for letting us know you couldn't hear. We wouldn't have known that. And we're working on a resolution now. Okay, we've replaced the mic, and if you would just like to begin again. I'm sorry to do that to you.
Can you hear now, Adam?
Adam, can you hear? Thank you.
Great. Yeah, so my name is J.J. Mays. I reside at 1128 Larrabee Street, apartment 2. So just to go over the 4 points briefly, with the parking spot, our parking spot that was previously held has been restored. And just a brief answer into why we feel it's better than the inside spot. The inside spot is against a wall, which is very difficult. It is also where the electrical and hose hookups are for the maintenance workers who work on the building. So we have previously had cement splattered on our car. We have had an electric cord rip up the bumper a little bit. So it's a very high traveled area that we prefer not to park in. But it has been restored and we are very happy, and that is great. In regards to the online payment, that has also been set up and restored. I'm having a little trouble with it in the amount that it's charging right now and been unable to adjust it, but the service exists, although currently I still have to pay by check in order to pay the correct amount, which is something I would love to be able to email about in regards to it. With the previous landlords, we were able to email them any problems, any maintenance issues, and the big reason for that is also it allows me to send pictures and to have a date of my correspondence so that I know where we stand in relationship to how we have communicated and a guarantee that we have communicated. Right now, those type of issues I have put in letters. The last time I sent certified mail, but I still have no proof of what was sent or what was paid other than the date I have it printed out on my computer. So that still continues to be a difficulty. As to the towing service, we live in District 4, which is the smallest parking district in West Hollywood. We live right up the street from the Viper Room, and us, along with other tenants throughout the street, can and have found cars just parked randomly in parking spots when we arrive home. The reason why we know that we no longer had the service was we came home one night to find a car parked in our spot. I'm an event producer. My fiance is a director of operations for Cinevita down in Inglewood. We both tend to work 12 to 16-hour days, so parking is a very essential thing to be able to come home and not spend time looking for something at those hours. But we found out we no longer had the service. We called the towing company that's been in use there for as long as Kristen has lived there, who lived here longer than myself, and she was informed she was no longer authorized to tow, which was something that they had previously done along with other tenants on occasions where they came home late to find people parked in their spot. But I believe that covers all of the issues that were addressed. So thank you. Appreciate your time.
Thank you. It's possible the commission might have questions for you at this point. Commissioner Thompson.
Yes, good evening, sir. A question. So you've been residing there since 2008 in your unit number 2.
My fiance has. I have been there for, I believe, 4 years.
Okay. So how many times since, how many times you have been requested the cars be towed?
I believe she has done it previously in her entire time there only 3 times. But we also currently don't have a 24-hour number where we can reach someone who is authorized. So if it were to come up now, we would have to wait till the morning to have any ability to remove the situation.
If somebody is parked, let's say, on that spot, would you call the landlord, ask for a permission, authorization to call the towing company, or you would just dial the towing company?
If it was during business hours when we could reach someone, it would be the landlord first. The reason why the tenants were authorized previously was because it tends to happen late at night. And at that time, our landlord also had no 24-hour line where we could reach someone.
And in what form that authorization was granted to you and maybe other tenants?
They were given the number for the towing service and told that if they had a late night problem, that they could call
Just
that.
call the
Yeah,
towing
I believe
company.
it came up with another tenant upstairs from us. It was the first time it happened, and he was unable to reach them. And so our landlord verbally told them that's what we should do to handle those situations after office hours.
Okay. So I'm just trying to understand if there is let's say it's a car is blocking or a car is parked on your spot, so will you just call the number without contacting the owner?
No, I mean, the first thing we would do was we have a text chain for all units together. So anytime there's a car that's wayward, the first thing that happens is a text within our building itself to make sure it's not someone who's there in accident or one of their guests that we can ask to move. And if after a good amount of time, like a half hour to an hour, nothing has happened, that's when they would call the towing service.
Okay, thank you. And the last question is concerning the email communication with the management. So when would you, when it would be required or not required, when would you typically email the management if you need some renovations or some issues, repairs done or anything like that? Or?
Yeah, the email would be for maintenance issues, to be able to inform them of it and also to provide like photo evidence of what's happening. For instance, we recently had a couple years ago, had a tree growing inside our wall. So we were able to send them pictures of what was happening with the wall for that response. And it allows me as a tenant to know that I have corresponded and that I have a time log of how long this issue has been happening.
Okay. Since if you're paying online, is that through online portal, the tenant portal, or it's how you pay online?
Yes, they provided a tenant portal. I think it's through a third party that allows us to pay online directly.
And does that portal provide also space where you can file a maintenance request?
No, it's just simply an account. You can't even. It is a number that is there, and the exact number must be paid. There is no ability to ask questions or to correspond.
Okay. So if there is no email communication, the last question, Chair, if there is no email communication with the management company, how would you address the maintenance requests?
Currently, I have put them in. I have attached a letter to my monthly rent check that I've sent, and we do have an office number with business hours we can call to inform them of maintenance issues.
And there is an emergency phone number?
I don't believe there is. I am not sure if there's an emergency phone number, to be honest. I've never had an emergency maintenance issue I've needed to use. I've always been able to, wait and talk over business hours.
Okay, thank you, sir. Thank you, Chair.
Thank you. You mentioned that there's a portal to pay, but the number is not correct. Is there a fee or something associated with that?
No, it's just the amount of rent stated on the letter in the reductions that is what I am currently paying does not reflect the same online, and I've been unable to contact anybody to make any adjustment.
Okay.
So because you cannot underpay the amount, those amounts have been adding up, so I can't adjust it, and I can't pay what I believe what the rent is stated versus what's online.
I appreciate the clarification. Additional questions? Seeing none, we thank you for your time.
Thank you very much.
Thank you, and we'll turn back to Mr. Rosencrantz for your rebuttal.
Thank you. So I'll just center my rebuttal on the towing issue. I think the tenant has affirmed that it was kind of hearsay evidence that was submitted to substantiate it. And secondarily, for JJ's fiance, who's been there for almost 16 years now, to say that there's only been an issue perhaps 3 times, I'd consider that de minimis. I'm not understating, the parking challenges that may arise, but I would just center it back on, it's imposing a liability on the landlord, right? If the landlord is ultimately the one who's responsible for any violation of the law or towing requirements, it doesn't make sense to impose or to allow a tenant to do that without the landlord's prior approval or even knowledge to tow somebody, and then the landlord to be held liable for an unlawful or inappropriate towing. So, the other thing too is I think the tenant may have testified that they called they called the towing company and they were no longer able to tow. That would imply that the landlord made an affirmative, choice or instructed the towing company that tenants could no longer do that. That's not the case. I didn't even know that there was a towing company previously serving the building. The prior property owner never gave us a towing contract. So I don't even know which towing company the tenant is referring to, with all due respect. And once again, it's the landlord who's liable for any wrong towing. So I can't see how anybody could reasonably assert that a tenant should have the right to do something that could impair the landlord without the landlord even having any knowledge or any ability to intervene. And lastly, there is not an iota of evidence of
That's your
anything ever
time.
shown to us that they were ever able to tow.
Thank you very much. Are there questions for the landlord?
Chair, I want to ask the landlord the same question about the email communication. Why it's a problem to communicate via email? I think these days it's almost a necessity, especially when there is no option for the tenant to submit a request, maintenance request online in the tenant portal. Do you know anything? Sorry.
So thank you for your question. I would note that this was not an issue that was appealed by the owner. I don't think that this was a part of the appeal.
So it was unclear in the appeal. When it's unclear and they say that the decision, if they check off all those boxes, we generally will put everything in. So that's why it's in there. If they're saying that they're not appealing it, then you can decide to affirm on the decision and not have a discussion on it. But generally when those check boxes are marked and it's unclear which ones, then we will do a full analysis on all the different options or matters.
Understood. Yeah, if it wasn't clear, I did not appeal that. I think in the couple of issues that I made comments on, that was not one of them.
Thank you. Thank you very much. If that's not before us by the person appealing, I think that that's pretty clear for us. Additional questions?
Thank you. There are no questions there. Thank you.
Vice Chair Rory?
One question. Have you submitted a compliance determination on the issues that seem to have been resolved?
I have not yet. I was under the impression that if it was, mutually agreed by the tenant and the landlord that that was no longer an issue of concern, that this commission could elect to, restore the rent that had been decreased by the hearing examiner under a basis that, there's no dispute as to that issue. If that's not the case, I can do it and will do it.
Okay, I don't think I'm supposed to go in a back and forth. I just wanted to get the information. Thank you.
Thank you.
Yeah, I appreciate it.
Commissioner Kerpes.
Yeah, I just need some clarification on what your testimony was during the hearing about the towing issue. The way I read the staff report, I'm sorry, not the staff report, but the decision by the hearing examiner, is that you may have taken affirmative actions to contact or to take away the service or to maybe change towing services. Did you take any steps, or did the landlord, the owner of the property, take any steps? Because that's how, now that I'm reading it a second time, I'm seeing that that may not be the meaning, but that's the way I read it the first time. So are you saying that there was no action taken to contact a tow company to say?
There was zero action taken to contact the tow company. Nobody involved with the ownership had any knowledge that there was even a towing service contracted for the building.
All right, thank you.
Have any additional questions? Then we thank you, Mr. Rosencrantz. We will now put you on mute again. Thank you for your time, and we will turn to commission
Thank you,
deliberation.
Commissioners.
Thank you. Commissioner deliberation, but I would like to start with a question for legal counsel, and that is, I know that the word hearsay has a lot of legal meaning. Can you enlighten those of us who are not attorneys as how we should be considering that word?
Excuse me, yes, I will give you the very law school answer and then I will explain what it means. So it is an out-of-court statement made by someone other than the witness to prove the truth of the matter asserted. So what does that mean? Is a witness saying, in this case, in this hearing, that someone else said something, and whatever that other something is being offered to prove the truth of that topic. It's very confusing. So in this case, the landlord's argument is that on that issue, the decision was solely made on hearsay evidence. I would say that is not the case. There is hearsay evidence in this. So if the tenant testifies, the landlord said we can tow cars, that is hearsay. But beyond that, what the decision says is not just they said we could do it from the landlord, but we had that ability ourselves. So they testified in their own voice about the service that was offered. So they are both offering direct testimony, which is from their mouths about themselves. We had this thing that was offered to us. That is direct testimony. It's not saying what the landlord said. It's saying, I am wearing a blue suit, right? Not Cameron is saying Kellen's wearing a blue suit. So the way I read the decision is that both statements were offered by the landlord, or by the tenant. What the former landlord offered us was a towing service, and we had that service as a housing service. I hope that makes some sense.
Thank you.
Can I ask a question, or is that not permissible?
It's not at this time. I appreciate you being here, but nothing else.
Understood.
Commissioners, additional questions before we get into deliberations? Seeing none, who would like to kick us off?
I think that we affirm on all of the matters. I would be interested to hear what everyone thinks about the tow service, because one, it's unusual. It was very rarely used. I'm not arguing that that is fully relevant, but I know in the reverse, we often find it relevant when something is more valuable because they use it more, like patios and things like that we've found in the past. So I would be interested to hear what others think about the tow service, because it doesn't sound, when I first read this, it sounded like the landlord to me in the decision was affirming things that were being said. Like he indicated that the tenants, actually, the hearing examiner says on page 31, the way it's worded, it says that you testified about the utilization of the towing service by residents was subject to abuse. I read that as like it was being abused, but now that I read it a second time under this context, I read that that could be an abuse. It could be subject to abuse rather than him denying the service because it was an abuse. In addition, and then there's only one other sentence at the very end of the hearing examiner's decision that when I read it the second time, I realized also does not say necessarily that the landlord took affirmative action to end it. The respondent indicated that the parking service was removed due to potential for abuse, but that's his analysis at this point. No longer is it the testimony that he's talking about the first time. So now that I've learned that the landlord may not even known about service, like it just happened to be that they had a service and it went away, but they didn't know, to me is questionable. So I'd like to hear what other people have to say about that part. But I'm ready to affirm on the other items. And I think just to clarify with staff, so the landlord is not able to singularly ask for a compliance determination on any of this 4 things that here are in front of us tonight, right? So he has to do one or the other, withdraw his application and check for the compliance, or?
Correct. The commission doesn't have the power to do compliance determinations.
Okay.
So whatever happens tonight, then they can file compliance tomorrow.
Great.
Commissioner Topchin.
Thank you, Chair. I'm pretty much in full agreement with everything that staff recommends besides this towing thing. After what I heard, and I appreciate Mr. Martz, I mean, your brilliant explanation is always the legal part of it. But what I'm not really convinced, I'm not persuaded that this is actually a landlord-provided housing service. When I'm reading the summary of testimony, and what it basically says is that the management, again, I would just say, allegedly, probably, the previous management provided them with the ability to call and have cars towed that were illegally parked. I don't know what that means. So, I'm kind of a little bit more of a strict understanding of what the service is. And I'm not suggesting that every service has to be in a written form, because we know that the service doesn't have to be in a rental agreement or any written document, because there could be a tenancy without a written agreement, and the tenancy may establish a relationship with the landlord and establish terms and conditions of the tenancy. That's not what I'm suggesting, but based on the testimony of both parties, and especially what I heard today, specifically asking the question to the tenant, since 2008, it was only, at least the tenant could recall, that there were 3 incidents when the cars were towed, the illegally parked cars. So, and also the landlord's testimony, which a statement that I cannot obviously disregard or ignore, that they've never contacted the tow company saying that, hey, never take calls from the tenants. So I don't believe this is landlord-provided housing service. That's my kind of understanding at this point. And because there's nothing that suggests that. So I understand the legal explanation by the legal counsel, but I want to have a little bit more to say, yes, this was a service provided to the tenants, and I don't see anything there. So to me, it's a hearsay, and again, I know the tenant can testify, and the testimony could have been, which is taken by the examiner as yes, the service was there, but I don't see it here. At least it's not provided in a way that I can be persuaded or satisfied with that decision. So I want to hear from the fellow commissioners on this.
Thank you. Commissioner McCafferty.
Yeah, I mean, I agree. I think the towing is an unusual service, but framing it with reminding myself that this is within the frame of did the hearing examiner make a reasonable decision? If 1, tenant testimony is acceptable evidence, and then 2, this definition on page 16 of a housing service, I'm not, again, like 100% convinced. However, that means that to me, that it is reasonable, that is the conclusion. So I am leaning to affirm the decision in whole.
Commissioner McCafferty, I come down the same place as you on the towing, in that I am also torn, which makes it, to me, feel reasonable. One thing that has not come up here, and probably it's because my guess is, something that stands out for me, but we haven't discussed yet, is this parking spot. And though it's been resolved according to both parties, there's an $82 a month reduction for the tenant should we affirm on that item. And I'm having a really hard time believing that the hearing examiner made the correct decision on that based on the evidence here, in that a parking spot was traded for another parking spot. And whether it was a better spot or a worse spot, it doesn't, it's a parking spot on site. And all that's, when, if a landlord removed a parking spot entirely, a hearing examiner would say one have to be reestablished. It wouldn't have to be the exact same spot, but there'd need to be some substantial compliance. So how in the world can taking one spot outdoors and moving it indoors not be considered providing the same housing service? So I'm having a really hard time affirming on the parking spot. I had some reservations about the towing, but I'm coming the same place as Commissioner McCafferty in that I believe it's reasonable. But the other two are very straightforward to me. So that's where I'm at this point in time, is reversing on the parking spot, but affirming on the other three. Commissioner Kirpies, yeah.
And when I first read it, I was too, like, one for one, you know, why is it 80 something dollars, $82? But as I read when I got to the decision portion and read the hearing, I mean, they provided the reasons why, and I don't know if you've ever been in a situation, but I've lived in a situation where it was a very tight turn, and by looking at the map, I can see their spot and how difficult that would be to get in and out of that spot versus just, so it made sense to me, their argument that they made in the hearing. And then I was also very impressed by, on all four of the items actually, by the hearing examiner's description of, okay, he looked at the total amount and he chose the least amount on each one of them, which I found impressive because a lot of these were kind of like, I'm not sure where I would fall on that. So I'm happy with what the hearing examiner and the process the hearing examiner used in that situation. That's how I came down to the side that I'm on for that one.
Commissioner Paris?
Yeah, I agree with the commissioner that the change in parking may not be a substantive change, but it puts an added hardship on the tenant. And that they've resolved it is fantastic, but they should, you know, go through channels to make sure that there's a compliance determination to that effect. On the issue of the towing, I think I agree with council that the fact that they had the ability to use the service is enough for me to say that a service existed, and in particular in the context of the area in which they live, whether it was once or a dozen times over the 16 years, that especially given that there is not a 24-hour hotline for the tenants to contact management to deal with parking situations, that it should be, they should use their agency power that was given to them by the ownership in the past.
Thank you. Commissioner Goldman?
Yeah, so I agree that the towing is a little bit of an odd one, but I do think based on I don't think that the hearing examiner erred based on considering the testimony. I mean, I'm wondering if maybe in the future there's a way for the landlord to provide a 24-hour hotline, maybe that remedies that. I don't know if we probably can't recommend that, but I think that might be a good compromise for the landlord and the tenant to allow something like that. But I'm inclined to feel like the hearing examiner did not err in the decision and to affirm all of them.
Vice Chair Rory.
So I think on the four issues, and I do think there are four issues on appeal. On the email issue, I would vote to affirm. I think that is a service, and I don't hear too much disagreement about that. On the online portal payment system, I also would agree to adopt to affirm. I don't hear any contention on that. On the parking, what I would say is that's why I asked up front if there was any pictures in the record. I'm assuming that the testimony we heard tonight about the reasons why it was inconvenient were what was told to the hearing examiner. And so based on that assumption, I kind of agree with what folks have said. If the hearing examiner thought it was a loss of service, then I'm fine affirming on that. I think there would be substantial evidence to support that. Although I note there were no pictures. I wish there had been a little bit more on that. And on the towing, I also vote to affirm, but my thinking there is that we've had other cases where housing services have been taken away. In my view, and I'm not saying that this one was taken away here because I know there's some dispute here, but there was a loss of a housing service for what I thought was a pretty good reason. Like, for example, there was some sort of bookcase or shelving that was in an emergency exit area, and the tenant was using that to store things, and the landlord wanted the space clear for exiting. And we were kind of bound by the law, which says even if the landlord is doing it for, a health and safety reason or, emergency exit, if there was a loss of a service, it's a loss of a service. Here, I think the landlord, I would understand as a lawyer myself, you don't want that liability, but shifting the liability is not the reason to justify a loss of a service. I do think that I'm comfortable there was enough evidence at the hearing about the ability to call the towing service themselves. And I'm assuming again that same testimony was provided that they did use that service at least 3 times. And I would kind of note for the record too that that's just this one unit. I mean, we don't even know how other units in the building that might have also called. And we live here in West Hollywood. We can imagine and I'm not hearing a situation where that was abused and the landlord had to eat a wrongful towing cost. These are all just hypothetical shifting of liability, which I don't think is reason to overturn the hearing examiner's decision. So for all that, on the 4 issues, I'm kind of in the affirm camp.
We have somebody prepared to make a motion at this time. Commissioner Kirby's.
Can I ask a question to council or to staff, whichever would be making the decision in this? And I know this is hypothetical. I hate those. But I'm reading the order, and the order is reinstate ability to request towing services for unauthorized parking. It doesn't say, get a number to a towing service that will respond to you immediately. It sounds to me like if the tenants had a number that they could call and it answered, and then could relay a call to the tow company to remove the remove the vehicle, that might be a reinstatement of the ability to request towing services. And maybe I'm just speaking out loud. That's my question is do you read it in a certain way that says that they have to use this company again?
So I wasn't clear on your kind of hypothetical, but what the decision says that the landlord needs to do is reinstate the ability to request towing services for unauthorized parking. So based on the testimony that the tenants gave at the hearing, the way I read that is they have to be allowed, if someone is parked in their spot improperly, to call 1-800-tow truck and have that guy come out without having to go through the landlord. If 1-800-tow truck doesn't want to come pick it up because they're not the landlord, that's not on the landlord. That's a separate issue. So it's just to have that ability. It is a little bit of a weird one because it's not a physical thing that was taken away, and it's so that's all it is. So it wouldn't rear its head until they actually need to use it. So it's kind of a vague order, but that's what it is.
Is there further deliberation or is there a motion prepared?
The question. Then
Commissioner
can,
Gerbes, please.
Sorry, another question.
No.
Then the question that came up about whether we can alter the decision. Does the commission have any ability to alter, clarify, redirect what the order is for reinstatement? Because to me it seems something like this for $29 a month in perpetuity, that's something that cannot be resolved or reinstated. To me, it seems a lot. So I'm wondering if we can clarify or make changes.
No, not particularly. Yeah, and I don't think it's on us to kind of guide the landlords or the tenants on how to do these things. You know, they have attorneys, and some of them are attorneys themselves. So I can think of ways that it can be resolved in my own head. So I think, you know, they're smart enough, and I know these guys are professional landlords. They've been in the game, so I think they can figure it out if they want to. They can also leave it and just not take the liability on, like the vice chair said, and it'll just be that rent reduction in perpetuity.
Vice Chair.
I'd like to propose a motion to adopt resolution RSC number 25-667, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision as to application number D4949.
Second.
I heard a motion and a second. Is there any further discussion on this? Seeing none, we'll ask for a roll call, please.
Commissioner Goldman,
Aye.
Commissioner Gerbes,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Commissioner Topchin.
I would probably vote no because I disagree that that's a service.
Vice Chair Rory,
Aye.
Chair Bass.
And no on the parking specifically. I know we can't divide our votes like that, but I want to make it clear that's the only part I'm voting no on. But that motion still carries 5-0. So if the parties have any further questions, you can reach out to the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. For Mr. Rosenkrantz on Zoom, you'll be put back into the waiting room now. If you'd like to watch the rest of the meeting, you can find your options to do so at weho.org/WehoTV. We'll now move on to item number 9. There will be an opportunity for public comment in just a moment if you'd like to speak at that point in time. But right now we're going to go to unfinished business, and there is none. And so we'll go to items from staff, number 10.
No items from staff at this time. Thank you.
Thank you very much. We'll now move on to item number 11. I believe Mr. Rosenkrantz would like to speak. You have 3 minutes to speak at this point, if you choose to.
Appreciate you. Thanks, guys. Thanks all. I appreciate your deliberation. I would just want to say that you deliberated with a fundamentally false premise, and that was that there's no emergency contact ability. There is an emergency contact number. It's posted in a common area of the building, so you guys were deliberating with wrong information that you didn't ask the landlord to clarify, and that was never proffered, right? If a tenant had a concern
Chair,
about a car being
this is only supposed to be on items
parked
not on the
incorrectly,
agenda.
Mr. Rosenkrantz, I'm being advised by legal counsel that we can't have further testimony on the item we heard tonight.
Right, I understand that it's been deliberated on. I'm not trying to reconsider it. I know you guys have made your decision. I'm just trying to clarify that you deliberated with false information. A tenant could just simply call the landlord for any issue and say, hey, there's a problem.
Adam, this is general public comment. It's items not on the agenda. So the public comment was for that portion, and this is for things not on the agenda.
Respectfully, he could just.
I'm going to take back control of the meeting. At this point in time, is there objections from the commission to let Mr. Rosenkrantz just finish with his 3 minutes?
No objection.
We can take no action, but you can continue with your 3 minutes.
Appreciate it. So I will not speak to this specific item, but in general, if there was ever a concern about any issue affecting a leased premises, the basic expectation that any landlord would have is that a tenant brings it to their attention and gives the landlord an opportunity to remedy an issue, especially if any implication has liability or any issue could have liability on the landlord. That would be a reasonable thing that anybody would do. So I would just caution the commission going forward to make sure that before deliberations on anything are done, that all of the requisite information is being possessed. And I fully respect every process that you guys take out, because I think generally the commission does a good job of, evaluating cases. And I know that you guys are doing this on your own time and for the betterment of the city. And I am appreciative of that, but I want to make sure that the commission takes the time to fully analyze all the facts and make sure that, information is correct before, that type of stuff is taken into consideration. Thank you.
I appreciate it, and I appreciate your redirecting your comments into a more of a general direction. Do we have any additional public comments, Madam Secretary?
There are no additional comments.
Thank you very much. So now we will move to items from commissioners. Do any of the commissioners have comments at this point?
I would just say that I did interrupt out of respect, and I totally respect and understand where the staff was coming from on this issue. But my point was simply that he could come back at the next meeting. Why waste everybody's time? And he could come back and say the same exact thing next week that would not be on the agenda. So why not let him speak now? But I'm glad we did. And so that's my thinking behind this. And it was, the action was already taken. So thank you.
Chair, may I briefly respond? So it's not allowed. So in the future, you can't do that. So I made clear that it's a Brown Act thing, public comment, and Commissioner Kirpies, you are correct. It is a little bit of a weird process, but the Brown Act is the Brown Act. So yeah, in the future we can't have those.
I appreciate that. I think that's the end of our meeting. This meeting this evening is adjourned, and our next meeting will be held on March 13th, 2025, West Hollywood Park Public Meeting Room, Council Chambers. That's this room. Have a good evening.
So we are at the groundbreaking for our AIDS monument, which will be here in about probably a year's time, and it will commemorate the amazing stories and those that we lost